the next topics we need to talk about are all somewhat different, but certainly apply to how we practice real estate. So let's make sure we understand it. And we look first at this advertising in real estate. Obviously, that's a big part of what real estate agents do. We do a lot of marketing, a lot of advertising. But there are some legal requirements when it comes to the advertising. And at least at the federal level, these laws are administered by the Federal Trade Commission, the FTC. Be good to remember that potentially. But the main requirement is when you're going to be marketing or advertising real estate, obviously other people's property. It says licensees cannot advertise or market the property without a written listing agreement. And I will tell you, I tend to see this, at least in my market, where agents will put stuff, social media is a big deal. People certainly use Facebook, for example, to do their marketing and advertising. And, you might see on social media where an agent's got, coming soon, house in such and such a neighborhood, a description of the house, maybe even a picture of the house. Well, what does coming soon mean? Have you listed that property or not? The law says you cannot be advertising that property without a valid listing agreement in place. Okay? Just because you're going to be listing it, later in the week does not mean you can start marketing it now. So I'm not really sure why we have all these ads out there, especially on social media, that says coming soon. If you have not listed it, if you don't have a written listing agreement with that seller to market or advertise that property, you better not be advertising the property. And then the second thing about these advertisements, it says, all your marketing and advertising must clearly identify the full name of the company you're licensed with. So there's no misunderstanding here. The public has a right to know if I contact you because I see an ad or whatever you put out there, then if you're a licensed real estate agent, I need to know that or should know that before I contact you. So you got to not only identify yourself as a real estate licensed professional, but it also says here you must also make sure you include the full name of the company you represent. Will be Caldwell Banker, Century 21, ERA, Exit, whatever it is. You got to put the full name. And notice it says full name. I'm telling you, there are some companies out there, large companies that are fairly well known, I guess, by their initials. But that you can't just put the initials of the company you work with. The law says you must have the full name of the company you're licensed with in all ads, all marketing. And I've had people ask me, well, if I'm putting it on my personal Facebook page, is that advertising? I think so. If not, then why are you putting it there? Right? That's marketing. That's advertising. So make sure we comply there. Then it also says, if the company or broker in charge has joined the MLS, which I assume if you're doing residential real estate at least, you probably have. Then it says the MLS must allow listings to be available for cooperative marketing programs. In other words, when you list a property for sale, and this will vary from MLS to MLS. Each MLS has slightly different bylaws on what their requirements are when it comes to listing property. But I think it's pretty common. Most MLSs will require when you list a property for sale, then you must you have to put it in the MLS, the multiple listing service, to allow cooperating agents to see it. Hopefully, if they have a buyer, they might even bring the buyer to you to sell the house. But some MLSs have different time frames on how much time you have from the time you list it until it has to be put in the MLS. You also just be aware of whatever the MLS requirements or bylaws are, depending on which MLS you're a member of. And then the owner will consent or may consent within the listing agreement. To put, they'll have something in the listing agreement where the owner is agreeing to have their property put on the MLS, or they may say you can't put it on the MLS. I don't know why they would do that, but apparently some do. But if you have a seller that says, I do not want my property in the MLS, you better make sure you know what your MLS bylaws are. Because I'm going to tell you, the one that we have here locally, it's pretty tough, some of the requirements there. Basically, it's saying if you don't, or until you put the property in the MLS, you cannot market the property. You better not have a MLS lot box. You better not have a for sale sign in the yard. You cannot market the property until it goes into the MLS. So the owner needs to understand. You choose not to put it in the MLS, there's not much at all I can do to help in terms of marketing and advertising. That's our MLS. I don't know that other MLSs are quite that stringent. But again, make sure you know what your MLS bylaws require. We kind of changed subject here a little bit, and now we need to talk a little bit about wholesaling in real estate. Well, first of all, what is wholesaling? This is something investors do, where, in a nutshell, they'll get a property under contract, typically for less than fair market value in most cases. But they'll get a property under contract. Now, obviously, we haven't closed yet, but it's under contract. And then they'll start looking for another person, maybe even another investor, but somebody else they can assign this contract to. In essence, they have maybe no intentions of actually closing on the property. They may have no intentions of buying this property. They just wanted to get it under contract. And then they would find somebody else that would be willing to pay more than what they're offering to pay. But just for example, say I got this house under contract for $100,000. It might be worth $130,000, for example. Well, maybe I can find a buyer that would be willing to pay $120,000 for the property, right? That's still a good deal for the other buyer because that's still $10,000 less than what it's actually worth. So it's still a good deal. Well, if I could find another buyer for this property, then I could assign, we talked about this in earlier chapters, but I could assign my interest. Remember, what interest do I have once the contract is accepted? Equitable interest or equitable title. I'm going to assign that to another buyer, where now they have the right to get it, but they're going to have to pay $120,000 for the property. So when they go to closing, they're paying $120,000. The seller is going to get $100,000, which is what he agreed to sell it for, and the other $20,000 difference is what the initial investor would make on the deal. That'd be their wholesale fee, if you will. That's called wholesaling. And you better be careful with this and know what the legal requirement, what the law says about wholesaling in your state. Okay. Again, we get into the state-specific portion. We'll talk about this a little bit more as it applies to whatever state you're currently in. But different states have different laws on this wholesaling. In fact, I'll tell you, a lot of states, if not and maybe close to all states, they may require that you have to have a real estate license in order to wholesale. Now, your state may not, but a lot do. So again, we'll tackle that some more when we get to the state-specific part. But for now, we just want to make sure you know what wholesaling is. And by the way, whatever that wholesale fee is you're going to be making, or whoever's doing the wholesaling, that has to be disclosed. Can't be hiding none of this stuff. Everything has to be above board. Okay? All right. Some other considerations, concerning wholesaling. It says wholesalers profit without purchasing, financing, or managing the property. Like I said, all they do is just get a property under contract, typically with little to no intentions of actually buying the property. They're hoping, before it's supposed to close, they can actually assign it to somebody else and make money on it that way. Again, many states require a license in order to do wholesaling. Investors must understand the local laws to make sure you don't get into trouble here. And whatever the fees are, whatever you're going to make on this as a wholesaler, that has to be disclosed properly. Things we've already really talked about, but you see it there again. And then, now we need to change the subjects again. Now let's talk about love letters in real estate. I will tell you, this used to be very common. I would help buyers do this from time to time. But what are we talking about when we say a love letter? This could be very advantageous back when we were doing it more often. If you had multiple buyers interested in the property. So a lot of times maybe a buyer, they would just write a letter. It's kind of like a love letter to the seller. Basically saying, letting the seller know how much they really love the house and just love your taste and the way you've decorated is just so nice and yada, 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 yada. Trying to make a connection with the seller. Hoping the seller would choose their offer over somebody, some other buyer. That was the intent of these letters. And again, we kind of call them love letters. But now, apparently, there's a pretty good chance you could get accused of discrimination when you do these love letters. So they really, they kind of frown upon these love letters. So I'm not saying you can't do it, but you better be really careful about what you put in your love letter to the seller if you do it. I might suggest you don't do it anymore. But it says a lot of these letters would reveal personal details like familial status, where they start talking about their children and stuff like that. They might have some religious comments in there where what an awesome venue to celebrate Christmas and stuff like that. And somehow, apparently, people take that as discrimination or can. Whether they intentionally meant to discriminate or not does not matter, whether it's intentional or unintentional. But if somebody files a complaint because they didn't get the seller didn't accept their offer, and they think it had everything to do with this love letter you sent them, and there are things in that love letter that could be considered discriminatory, then you could have a violation under the Fair Housing Act. You could be hit with a discrimination charge. So, you don't see these love letters too much anymore, I guess. So, just be aware of the unconscious bias. Sellers could be influenced unintentionally. There are some legal risk if you're going to do these love letters. They're not saying you can't do it, but they are saying that they're going to be looking really hard at what you have in that letter. Okay, But it says realtors and sellers can face consequences if discriminatory decisions are made. So, I think long and hard about that love letter. Now, we offer some best practice for advertising and offers and stuff. But make sure all your ads include the fair housing logo, the equal housing opportunity statement, and so forth. Be a really good idea to do that. Make sure you don't have any kind of discriminatory language or pictures that could cause somebody to file a complaint. Evaluate any offers strictly on financial and logistical terms. Try to keep the personal stuff out of it. They even say to discourage buyer love letters to minimize these legal risks. And make sure we follow the HUD and FTC guidelines very closely. Again, the FTC, the Federal Trade Commission, they're the one that administers these requirements when it comes to advertising. So, got to be very careful about all the fair housing, the ADA, all this stuff we've talked about up to this point. You do not want to get in trouble with any of this stuff.